Good evening to the last students of the SLW-646. Karibu sana for my virtual class. Anyone can unmute and read what I posted on the screen? Haraka. Yes, anyone can unmute and read. Yes, I will read it. Because now the Raymond Cosmos have joined. Raymond Cosmos, unmute and read what I posted on the screen. Raymond, unmute and read what I posted on the screen. Yes, Raymond again disappeared. Okay, welcomes to the students of the SLW-646 to my virtual class on the topic of the law of the sea on 16-02-2023, 9:10 to 10 p.m. And I'm the course coordinator, Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, St. Augustine University of Tanzania, Mwanza, Tanzania, East Africa. Then without wasting the time, let us go to our studies. And this is the syllabus that we do have it. And if you happen to see the syllabus, dispute settlement of the civil nature, International Court of Justice, we dealt in the last class. In this class that we would like to deal the law of the sea, International Tribunal for the Law of the Sea. That we are going to deal today in the class. Yes. Now, better we will start our things are concerned. This is the environmental law, but we are going to do the next class, that thing. And today class that we are going to deal, yes, I already put it over here, proposed 646. Yes, the law of the sea. That I am going to deal today class, the law of the sea. Yes. Could you see on my screen that what I posted on the screen, the law of the sea?
Yes, Prof.
Yes. Then International Tribunal for the Law of the Sea. And if you want to know that where is this law of the sea is situated, and where the International Tribunal for the Law of the Sea is situated, say Mungu najua. Do you know Mungu najua?
No, Professor, I don't know.
Okay. If you see the law of the sea convention is there, the headquarters is there, Jamaica, Kingston, Jamaica country. But when you happen to see the International Tribunal for the Law of the Sea is there, Hamburg, Germany. And we are proud of, the Tanzania is very much proud of it. The first case law, M versus M/S, is a contended, not advisory. And where two countries are involved over there, and there the judge is, you know who is the judge in the International Law of the Sea, Hamburg, Germany. He is from Tanzania. Do you know who is he? Any idea? Rough idea?
First one, sir.
It is decided in the 1967, the case law. But when I read the case law, I found judges from the various country. Cameroon is there, India is there. Then I was read all the judges from the various countries. Then I found Tanzania. And when I read the name, his name is Joseph Sinde Warioba. Have you heard the name?
Yes, Prof.
Who is he? He was a president?
Was a former AG.
So, he was the judge there in that case law, the first case law from the Tanzania. Okay, now let us see the tribunals. The International Tribunal for the Law of the Sea is an independent judicial body established by the United Nations Convention on the Law of the Sea to adjudicate the dispute arising out of the interpretation and the application of the convention. The tribunal is composed of the 21 independent members elected from among the persons enjoying the highest reputation of the fairness and integrity and recognized the competence in the field of the law of the sea. From various countries, those who are the members of that UN Convention on the Law of the Sea. The tribunal has a jurisdiction over any dispute concerning the interpretation or the application of the convention and over all matters specifically provided for any other agreement with confer the jurisdiction on the tribunal means statutes, Article 21 especially of the UN Charter. The tribunal is open to the state parties to the convention, that is the states and international organizations which are the parties to the convention. It is also open to the entities other than the state parties. The other people also can approach to this law of the sea tribunal, or states or intergovernmental organizations which are not parties to the convention also can approach them, and to state enterprises and private entities in any case expressly provided for the part 11 or in any case submitted pursuant to any other agreement conferring the jurisdiction on the tribunal which is accepted by all the parties to the case. Even the parties, those who are not the members of the convention, can also approach. If the two parties want to approach to the law of the sea tribunal, yes, they can approach under the statute, Article 20. The United Nations Conventions on the Law of the Sea. And this convention on the law of the sea was opened for the signature at Montego Bay, Jamaica on December 1982 and entered into the force on 28 July 1996. It is 1996. The first case law is 1997. A subsequent agreement relating to the implementation of the Part 11 of the convention was adopted on 28 June 1994 and entered into the force on 28 July 1996. Any person or any states can submit themselves to it, even though they are not party to the convention. This agreement of the Part 11 of the convention are to be interpreted and applied together as a single instrument. So the convention established a comprehensive legal framework to regulate all ocean space and its uses and resources. It contains, among other things, provisions relating to the territorial sea, the contiguous zone, the continental shelves. These are all you study in the public international also in the law of the sea, because every country having a touch with the ocean or the sea, then how far that you could have a right to fish in the sea, and what is your jurisdiction from your border to the middle of the sea, 3 nautical miles, and that's a different, say, contiguous zone, continental zone, the exhaustive economic zone. These are the zones under the high seas where the country will enjoy it, and which country is very adjacent to the sea or the ocean. Is it clear?
Yes, Prof.
Can you tell me the difference between a sea and a ocean? Yes?
Sea is the huge one.
See, when you
Contains,
say the sea,
yes.
which is entering to the area of the country or adjacent to the country, generally we will say the sea, like Arabian Sea, Indian Ocean, Bay of Bengal, and Atlantic Ocean. When all the sea together become a ocean, but different places we name it, like a Red Sea is there. Red Sea. Where is the Red Sea? Asmara,
The Far East.
Ethiopia, Eritrea. There is a Red Sea. And
Okay.
approach to the near to the country is a sea, but the sea is a part of the ocean. Am I right? The entire thing you can say ocean. So here we speak about the continental shelves, and we'll see with the contiguous zones, and we speak about the exclusive economic zone where you can fish, but you cannot fish in the high seas. It also provides for the protection and preservation of the marine environment, for the marine scientific research, and for the development and transfer of the marine technology, and the law will protect it. Nobody could exploit it. One of the most important parts of the convention concern the exploration and exploitation of the resources of the seabed and the ocean floor and subsoil thereof beyond the limits of the national jurisdiction of the marine environment. In the deep seas, there are many aquatic plants are there. Coral reefs are there, which are costly in nature, and these plants can be used even for the medicinal purposes, or the marine creatures will eat these plants also, and they will survive. So in the seabed there are treasure is there. So people will not try to exploit such a treasure, but only to certain extent they can exploit it, but not to the beyond that, because that comes under the high seas. It provides for the protection and preservation of the marine environment, for marine scientific research, and for the development and transfer of the marine technology. One of the most important parts of the convention concerns the exploration for the exploitation for the resources of the seabed. There are many coral reefs, many seeds and many plants, and many type of the fishes in ocean floors and subsoil thereof beyond the limits of the national jurisdiction of the area. So the convention declares the area and its resources to be the common heritage of mankind. The International Seabed Authority, established by the convention, administers the resources of the area. There is the International Seabed Authority is there. Nobody could exploit such a seabed resources, marine treasures, coral reefs, and the plantation flora and fauna on the subsoil or the deep soil of the sea. So when the disputes comes over there, part 15 of the convention lays down a comprehensive system for the settlement of the disputes that may arise with the respect of the interpretation and application of the conventions. It requires the state parties to settle their disputes concerning the interpretation or the application of the convention by peaceful means indicated in the Charter of the United Nations. Those who are the members of the state, if any dispute comes regarding the marine, flora and fauna, seabed, coral reefs, treasure, seabed, any other point, yes, the disputes will be settled by the UN charters. There is a provisions, and the matter refers to the International Tribunal of the Law of the Sea, which is there in the Hamburg, Germany, consisting of the 21 members, judges, hailing from the different countries, nominated by the countries. So, however, if parties to dispute fail to reach a settlement, in case if they fail to reach any settlement between the states by peaceful means for their own choice, they are obliged to resort to the compulsory dispute settlement procedure, entailing the binding decision subject to limitation and exceptions contained in the convention. The UN Charter clearly makes if any settlement is not come out of the dispute among the or between the states, then the final resort is the International Tribunal of the Law of the Sea, which is a statutory body enacted by the United Nations Charter. So, what would be the jurisdiction? I told you already in the beginning, even the parties are not to the convention can also approach if both the states will agree to approach to the International Tribunal, Law of the Sea. So the jurisdiction of the tribunal comprises all disputes submitted to it in accordance with the convention. The convention established this International Tribunal of the Law of the Sea. It also extends to all matters specifically provided for in any other agreement which confers jurisdiction to the tribunal. If any other agreement confers the jurisdiction of the tribunal, even such cases also will be dealt. The two type of the cases are there. One ten contentious means contesting disputes. Another is advisory disputes. So, to date, 16 multilateral agreements have been concluded which confer the jurisdiction on the tribunal. So, 16 multilateral agreements are there and which confers the jurisdiction of this tribunal and relevant provision of these agreements. In addition to that, unless the party otherwise agree, the jurisdiction of the tribunal is mandatory. In cases relating to the prompt release of the vessels and crew under the Article 292 of the Convention and to provisional measures pending the constitution of the arbitral tribunal under the Article 290, paragraph 5 of the Convention. These articles will empower it and mandatory regarding the prompt release of vessels if any vessel is detained illegally, including the crew. So they do have interfere in that matter. No vessel can be detained in any water of any country without any legal excuse, without any permission from a competent authority. If any matter would be there, it will be bring to the notice of the law of the tribunal, and tribunal will solve the problem. So the seabed disputes chamber is competent to give advisory opinion on the legal question arising within the scope of the activities of the International Seabed Authority. So we don't think that there is a lot of treasure in the international seabed, means high seas, in the international seabed. There is a coral reefs, there is a different species of the aquatic animals, aquatic things are there. Even plantation is there. Even a good greenery would be there, and which is very much useful for the either for the consumption or for the medical benefits are concerned. So the tribunal may give the advisory opinion in certain cases under the international agreements related to the purpose of the convention. So the International Tribunal of the Law of the Sea, it can give the two types of these: contentious jurisdiction and advisory jurisdiction. The disputes before the tribunal are instituted under by written application or by the notification of the special agreement. The procedure to be followed for the conduct of cases submitted to the tribunal is defined in the statutes and rules. How we can file a case, how it can be admitted, so all the procedures should be there in the statutes and rules if any dispute arises regarding the seabed, regarding the marine issues are concerned, regarding the seizure of the vessels are concerned. So the mechanism established by the convention provide for the four alternatives, means for the settlement of the disputes. What are those four alternatives? Number one, the International Tribunal for the Law of the Sea. Yes, it can be resolved if any dispute comes over there. Number two, the International Court of Justice. It is also a body of the UN and where the member of the state or the state themselves will submit to the International Court of Justice also to resolve any issues. And number third, an arbitral tribunal constituted in the accordance with the Annexure 7th to the Convention, it can also be resolved the tribunals, and the special arbitral tribunal constituted in accordance with the 8th of the Convention. So there are four types alternative ways are there to resolve the issues are concerned. Number one, it is the International Tribunal for the Law of the Sea. It can also resolve the issues in the marine matters are concerned, in admiralty jurisdiction is concerned. And the number two is the law of Permanent Court of Justice, that is the ICJ, which is in the Hague, Netherlands. So, in addition to that one, if the tribunal also constituted by depending upon the situations under the Annexure 7 to the Convention is there, especially, and a special tribunal also in accordance with the 8th of the Conventions. So, these are the four alternatives, bodies are there where the dispute can be adjudicated or disposed or resolved. So, a state party is free to choose one or more of these means by a written declaration to be made under Article 287 of the Convention and deposit with the Secretary General the United Nations declaration made by the state parties under Article 287. Yes, if any party would be there would want to resolve the issue, they can give an application in which way they want to resolve their disputes regarding the marine matters are concerned. So, if the parties to a dispute have not accepted the same settlement, yes.
Professor, I have the question.
Yeah, please ask.
So the choice of the parties on both methods, they can be applied consecutively, or they can choose to start with the one method and then when it fails, they go to the other method.
See, the point is, a party can choose which way they want to resolve the issues. Either they can go to the International Tribunal of the Law of the Sea, or they can go to the ICJ also. But if the matter is connected with the admiralty jurisdiction or marine jurisdiction is concerned, ICJ doesn't have that much expertise when you compare with the law of the sea. So, generally it is redirected to the party, go to the law of the sea because it is a competent court. For instance, if they fail to get it from the law of the sea, because law of the sea is a tribunal, at that instance, aggrieved party, if they want to appeal it, to whom it can appeal? Generally, the only one court of the UN Charter is there, that is the ICJ. In general, ICJ will take up such a cases if it is necessary, or the General Assembly having a right to choose any one of the tribunal or any other special tribunal will be appointed or created to resolve such an issues. Regarding the cases are concerned, yes, sometimes the case which is given is final judgment. There is no appeal. In cases, if they refer it, perhaps I don't think that there is a division bench should be there. No, all 21 judges will sit and admit the case. All 21 judges give the judgment separately, and some of them assenting judgment and some of them dissenting judgment. But majority is the law, hence those who are giving the assenting judgment, that is the judgment which will be implemented. And in this respect, even let us see the cases, how it can be made, and which court is having the jurisdiction, suppose if they fail in the lower court. But to my knowledge, once they submitted it and the judgment is given, perhaps that would be the final. It's my opinion. But alternatives are there, no doubt. But alternatives also will see whether they are an expert. The tribunals are expert or not is again the point. So when the tribunals are expert in a particular respect, then they will say, yes, go to this special tribunal because their judges are very expert in that area. For instance, you take in the Tanzania, there is a land dispute cases are different. A land division is different. Am I right?
Yes, Prof.
And the family division is different. And the company or labor division is different. If once the High Court has given the having the same equivalent right of the High Court, land division or the labor division or the family division, then only appeal is the Court of Appeal. Am I right?
Yes, Prof.
But in this area, to my knowledge, if once a special court has given, then there is no appeal to the second, because I did not see the appeal cases here. But in different category, you can approach to the same court, because all 21 judges will play the role here. All 21. Even admission also. In admission or jurisdiction or something, yes, these judges not agreed and these judges agreed. So who agreed the most number, that will be prevailing. So in my knowledge, a special tribunal or the tribunal or the ICJ or the law of the sea, depending upon the nature of the cases, it will be dealt. Because all these bodies from the UN Charter. Am I right?
Yes, Prof.
These are all the things from the UN Charter only. So it is the UN Charter will decide it where to give and what to give. So the state party is free to choose one or more of these means of written declarations to be made under they say one or more written declarations to be made under 287 of the conventions and Secretary General of the United Nations declaration by the state parties under the. So see, if they want, to me, they can file in the different. I don't feel that they can file it in the two places at a time. If they fail in, say, a ordinary tribunal, then ask for the special tribunal. That way they can approach it, to my view. So a special tribunal is more having power and its verdict is final. So tribunal is open to the state parties to the convention in certain cases, to entities other than the state parties such as the international organizations or natural or legal person access to the tribunal. Even international organization also can approach to the tribunals, and the natural or legal person also can approach to the tribunals, and the tribunals has access to all the people, even though they are not thus parties to the state. So thus the cases will be dealt by the International Tribunal of the Law of the Sea. And here I saw the cases judgment, like I told you, M is judgment. Yes, this is the judgment. Saiga. M/V. That is the way of writing the case law. So International Tribunal for the Law of the Sea, the Tribunal International, because the two languages are there. Number one, English. Number two, French. So press release issued by the registry, hearing the concluded in the M/V Saiga case judgment order prompt release. And here what happened in short, it is a Saiga is a a vessel carrying the oil tanker it is. Saiga is a oil tanker. It is carrying the oil from whether passing from the Conakry, Guinea. A tribunal delivered its judgment and ordered the prompt release of an oil tanker M versus V Saiga and its crew from the detention. The crew members are detained, the vessel is detained. Where? In the water of the Guinea, that is Conakry of the Guinea. So in addition to the cargo, gas oil and St. Vincent and the Grenadines are to deposit 4,000 USD United States of dollars as a security for the release. They said we want to release it, but we have to secure this much deposit because they detained this vessel in the impression they are making the smuggling. The vessel is making the smuggling. So that's why they detained it. The judgments delivered by a public sitting in the tribunal in the Great Hall of the Hamburg City Hall with the full bench of 21 judges and the registrar sitting over there. And the president is Miss Mensaha. Mensaha read the judgment. But actually the president Mensaha, he has given the dissenting judgment in this one. But still, ascending judges are more, and hence he could not do so. The case concerned the arrest of the coast of the West Africa, Guinea of oil tanker MV Saiga. They arrested it, they detained it, flying the flag of Saint Vincent at the Grenadines. So Guinea claimed that. What the Guinea claiming? The Guinea, the country claimed that the MV Saiga was engaged in smuggling activities of its coast when arrested. They are doing the smuggling activity in their coast when they are arrested. The arrest at a point outside the Guinea waters, allegedly flowing the clause chase, was claimed to be an exercise of the right of hot pursuit. Guinea also maintained that the tribunal had no jurisdiction in the matter, that the claim was inadmissible. But Saint Vincent and the Guinea accused of the Guinea of the piracy. So, overall, what they said is, it is a false allegation. They should have to release the vessel because it doesn't have any smuggling business over there. But actually, they chased this vessel to come to the Guinea land and they seized it. And they said they are doing the illegal business there. So, the court decided that the seizing of this vessel is illegal. You cannot detain the crew as well as the vessel which is carrying the oil. So that is the whole judgment which is given, and here there are ascending judgment. The more detailed account of the judgment will be available in further press release, and the tribunals are given. The judges, having completed the deliberation in the case, set up the drafting committee in accordance with the international judicial practice of the tribunal. The committee is composed of the 5 judges holding the majority opinion. The draft judgment produced by the committee went through the 2 readings. After such a final was taken to adopt the judgment, the judgments delivered 6 days after the end of the oral proceedings. The judgment was unanimous as to the tribunal having the jurisdiction, but divided 12/2-9 on the question of the release. The dissenting judge of filed 2 corrective dissenting opinions and 2 dissenting opinions by the individual judges. But overall, they said the vessel should be released. The vessel should be released judgment which is given by the court. So you will have many such a judgments should be there, but it is the first judgment given and where the judge is Variyaba. See, here I am showing P. Chandrasekhar Rao, India. Did you see? Did you see? Participants.
Yes, Prof, we can see.
And who is from Tanzania? Here I highlighted. Who is from Tanzania? Who is from Tanzania?
Joseph Sinde Warioba.
Why you are taking so much time to read? So Joseph Sinde Warioba also one of the judges in this case law. So the members of the tribunal, President Thomas A. Mensah, is Ghana, Vice President Rudiger Wolfram, Germany, Judges Liaki Jaho, China, Hugo Chimonos, Argentina, and Brazil, Bulgaria, Japan, Russian Federation, Republic of Korea, and Cameroon, Grenada, India, United Kingdom, Croatia, Tanzania, Belize, Italy, Tunisia, Iceland, and Senegal. So these are all members of the law of the Betsy. From each country, they will select it. Of course, there will be a tenure or there, either 3 years or 6 years, 9 years tenure. After that, whether will be elected or re-elected, the constitution or the act says whether a person can be re-elected from the country or not. So with that procedure, they will choose the judges from the various countries, and it is the International Tribunal for the Law of the Sea. And matters, some of them will be referred to the ICJ, which are in plain in nature, perhaps. Otherwise, the matter would be settled down by either the tribunal special or the tribunal separately, a different tribunal or a special tribunal will be constituted if the matter having such a high importance over there. In that way, the matter would be resolved regarding the marine disputes are concerned and the seabed disputes are concerned, continental shelves, economic zones are concerned, even sabotaging or the piracy cases or the pirate cases also will be entertained by the seabed, because piracy would be done on the vessel. The pirates, sea pirates, the vessel. So hence, such a thing will be dealt by these international. And the tomorrow class that we will see, the environmental issues are concerned, and that is called International Environmental Court should be necessary to dispose the cases. That is that we will study. Environmental, that is a proposed international court for the environment. So there are many environmental issues are come out in the India, in various countries in the world. There are high environmental cases are there, and the pollution is there, and the depletion of the ozone layer is there because of the carbon monoxide, and these are all some drastic issues are there, and for that also they do want to dispose the case. Asante sana, sikiliza darasa. Mungu akubariki na kukulinda.